Welcome to this podcast with Julian Wilkins from Blue Pencil Media, our almost pretty much resident London Screenwriters Festival legal team who's available at the festival to run the legal clinic. But ahead of that, we have organised to go through a bunch of very, very common legal questions people have so that we can clear those decks and focus on more specific problems. So welcome, Julian.
Thank you, Chris. Good to see you again.
What's your impression of the festival and the delegates? My
impression of the festival, I've always been a big fan of the festival, and I'm not just saying that because you give me cups of tea and things, but it's got a great atmosphere. I think it gets better every year in terms of speaker content. I think the delegates are great. I mean, I think you do feel as though you're part of a unity. You feel as though it's sort of like a homecoming because everybody's got a common spirit and there's camaraderie and they've all got they've got shared experiences. So I think it really does what it says on the tin, to be honest.
Right. So what we're going to do is we're going to go through 5, 6, 7 questions, and these have been amalgamated from lots of questions we've had over the years, and they're kind of like the top questions that come in from the form when we ask people to submit legal questions. So let's just get straight into it. So number one question, which I think is probably the most common question I've ever heard in a legal context. I've got a great idea for a story, but how can I protect it?
Yeah. Well, I think in terms of idea, you can't protect an idea. If you've got a great idea, go and turn it into a script. Then you've got copyright in the script, so you automatically get copyright.
So just to be clear, by writing something but under UK law, you actually own the copyright by doing that?
That's right. Copyright, I mean, it goes back. I mean, it started off as a common law concept and then it's being regularised by statute. But basically, the minute you write a script, you automatically create your own copyright, provided you can demonstrate it's an original work, it's your original thinking. It's not so much the idea. Copyright's about protecting the manifestation of an idea rather than the idea. You and I can come up with a detective story set in a manor house where the butler does it. I can't stop you writing that, but you and I will write it in a very different way, I'm sure. And it's that different way that we protect.
So 2 thoughts come out of that. The first thought is there's some people who are offering copyright, protection services online. There's kind of no point in doing that. Or maybe the point is that just kicks in, should there be a legal issue that arises, then that provides some proof that it existed on a particular date and time.
That's right. I mean, I don't want to do, one of the leading ones is the UK Copyright Service, and they do a great job, but I think because it's an automatic right, you could just say, well, I've written the script, I'll put it in the drawer. Where it's important is to prove when you wrote it, who wrote it, particularly if you're starting to circulate the script to third parties, whether it's production companies, agents, whatever, and you want to make sure that people are not plagiarising or lifting chunks of your work. And so these organisations are good for registering with them. Also, it puts you into an international domain because you can. It's an international site, and people can search on that site and see what work's been registered.
And what's the name of that site again?
Well, the main one is the UK Copyright Service.
Right.
Sometimes the best ways, the stop ways of protecting it, or registering or proving your copyright, is either register with the UK Copyright Service, and there's a fee, and their fees are on their site, and they vary from time to time. The other thing is to write your script, post it, special delivery, so as proof of posting, either to yourself, and if you send it back to yourself, don't open it, keep it sealed, and it demonstrates the date when you sent it, or alternatively to a trusted friend, or a professional person like a lawyer or an accountant. And then some people actually, I know that it's less often in this country, and quite often it's more established writers do it, is they sometimes register their copyright in the Library of Congress in the US. That's quite a known.
I think that becomes also an imperative once your film has been produced, especially at a low budget. You know, you as a writer, you'd probably stay involved in that process and be involved in the registering at the Library of Congress, because it's part of the sales deal. You can't sell a film without that being in place. And again, the second thing that comes out of this then is the common question of somebody ripped off my idea, but actually it's probably more likely they just had a similar idea and followed a similar thought pattern. Obviously, you can't protect yourself from that, but do you have any thoughts on not getting paranoid and accepting that actually probably the best course of action is to get it made?
Well, yes, get it made. I mean, I think the modern day technology allows you to, even if you just did a short version of it, you know, I know that certain writers are getting a 20-minute film. Two reasons for it: A, it's a way of galvanising some legal rights. B, it's a way of getting noticed because they put it into festivals, etc. And it's a great marketing tool, but it's a work of art in its own right. It depends what the idea is. I mean, if you've come up with something so oblique and so wacky that all right, statistically somebody else will have it, and you can demonstrate that you did show it to Joe Bloggs, and then suddenly Joe Bloggs is doing something incredibly similar to what you're doing, then you may have some redress. But a lot of that's down to evidence, really. I mean, where that sort of area, not going off too much of a tangent, but where the sort of trying to protect ideas is very much in the area of format rights, particularly for TV and things like that, where that is very much about you know, if you've got an idea for a game show or series, and then somebody does something very similar, they have quite often, there's a number of disputes worldwide about arguments about, well, hang on, you're stealing our format or copying our format rights. But in terms of pure scripting, unfortunately, if two people come up with a similar idea, you not a lot you can do. It's plagiarism is the thing you can protect against.
I think it's also one of the reasons why, unfortunately, so many production companies won't take unsolicited scripts, because they know if it comes via an agent, that the writer is not going to start to make kind of unreasonable claims that, you know, you read my script and now one line of dialogue has appeared in something similar, you know, from your company 5 years later. And I think that's one of the reasons that drives production companies to just not take unsolicited scripts, because a new writer can be, you know, everything from totally reasonable to completely bonkers.
Yeah, and I've met with writers that are so paranoid that they don't actually get out there and they're so frightened of somebody taking their idea, they don't do anything with their work, which is a bit
I can't possibly pitch it because then people will know what my idea is. There's a little problem with that.
Well, it is. I mean, the main thing is if you come up with a great script with some really great original dialogue, and I think, Chris, you're the better person to comment on this than me, but I think they recently did a survey about memorable dialogue, and sadly it seems to go back to films 10, 15, 20 years ago. So really, you know, if writers can come up with great memorable lines, that's, you know, and that's your creation. You can protect that if you see those lines appearing in somebody else's script.
Okay, let's move on to question number 2 then. What is an option and how does it operate in practice?
Well, option is a process that's used in the film and TV industry to ring-fence the rights to either a script or book. And what it essentially means is that, say you're a producer, you like a script or a book and you want to develop it potentially into film or TV or whatever, you go to the writer and say, I want to option it, and it's an agreement whereby the writer agrees to the producer to having or production company to having the right to purchase the script within a particular time frame. So it's a bit like a ring fencing. So the writer can't just go off and say to one producer, yeah, fine, I'll work with you, and then 5 minutes later they're talking to another producer and doing a similar deal. Once you've been optioned, you're contractually bound to that producer for a period of time. And in that time, the producer has the right to try and raise the finance and work often with the writer to develop the script. If it's a book that you've optioned, then it would be either to write with the author of the book, or alternatively look for third-party screenwriters to develop that into a script. Most options have two parts to them. There's the option to just ring fence for a period of time, and that's a matter of negotiation. The usual option periods vary from probably 1 to 3 years. It's very unusual to have something that exceeds 3 years. It's possible, and I have seen 5 years, but I think that's at its limit. And the second half of an option agreement is the purchase. So say you, the producer, have raised the money to, say it's a script you've optioned, you would then have in the second stage in the option agreement, I've got the money, this is the agreed term, you, the writer, will get X pounds. As a consequence of that, I now own the rights for the film, or whatever rights you're willing to give away as the writer. And then usually a third part of an option agreement is the back end. Once the film's being made, or the TV program, the writer would be entitled to further payments, royalties, or percentage of profit. It varies on deal to deal.
So it's quite a simple agreement, really. In principle.
In principle, but there's so many things that need to be thought about. Obviously, money is an important one. Defining what is going to be paid to the writer at what point, what rights you optioning, i.e., what rights are being ring fenced, and then what rights are going to be purchased if it gets to that stage. You may only option the right for the producer to do a film. Meanwhile, you can go and develop it as a theatre play or radio play, or you may. I mean, it is true that most producers, and certainly the investors behind the producers, quite often want most rights in the option, because they want to exploit the script in every which way they can.
So, if I'm going to do an option agreement, should I? I mean, the Guerrilla Filmmaker's Handbook, the book that I wrote, has got an option agreement in the back, and it's pretty, it's a hefty contract. Should I just sign that, or do I need to go get a lawyer? And I know you've not read it, but in principle, is it okay to just use a form option agreement, or should you really go for legal representation and do it that way?
I mean, the biggest problem is for a lot of writers is do they have the means to bring on professional help at that stage? I think in the ideal world, I would get independent advice. I'm not just saying that because I'm a lawyer, because it depends who you're dealing with, but you're quite often dealing with production companies that would probably be insisting on using their own terms and conditions, which might even be even more longer in form than what's in your book. There might be a lot of terms in there that you may not be familiar with, and way things are worded, and also you have quite often the attitude is, here's the agreement, sign. But I think any person entering into a contract should have the options, the availability to amend and say, well, I don't like the term on that, it should read like this, or whatever. And I think, and the old saying, physician heal thyself, it's not always a good idea. I mean, as a lawyer, I would not advise myself on an agreement that applied to me personally. I think you need that independent third party to look at it. But it depends on how savvy you are. I mean, if you are commercially savvy, if you are very familiar with these agreements and you feel comfortable, then it'd be wrong of me to say no, go solo. But if you can get some form of independent advice, go for it.
So in some ways, don't just get so excited that somebody's interested in your script. No deal is better than a bad deal. Absolutely,
I couldn't agree more. It's it is the excitement. I know what it's like. People, I see it. The enthusiasm. Somebody's interested in and offering me a bit of money or whatever, and I can see that, understand it. But then you got to calm down, step back, and say, well, what are the implications?
One of the hardest lessons I ever learned, this going back 25 years on my first film, when I was doing a deal with the producers, and I got upset about something. I said, that's really not fair, that part of the contract. And he looked at me and said, you don't understand, do you? He said, you don't get what's fair, you get what you negotiate. And that really hit me hard. I was like, yeah, this is a different world. This is not the world of mates making films. This is a real world with money and moving parts and, and legal implication and chain of title, which we've not even discussed in relation to the option agreement. But I suppose for a new writer with their first script written only by then, hopefully goes to one production company, there really isn't going to be much chain of title. But if it bounced around between lots of different production companies for 15 or 20 years, it can get a little bit complicated.
That's right, and particularly if all the agreements are a bit different. Some talk about XYZ rights and the other one's got ABCD rights. So
I've got a story. It's based on real life events. What are the problems and the challenges and the pitfalls involved in writing I guess at one end, absolutely it's based on real events, and at the other end, it's inspired by things that happened, which basically means we're making it up, apart from some very ephemeral connection.
I think starting at the latter point, where it's inspired by, I think that's an easier call because because you essentially it's your thoughts, your ideas. If you're creating characters, and you're using different names to real life names, if you're basing it around actual people, for instance, then you're in fairly safe ground. I mean, the only caveat I would say, even if you have a character and you use a fictitious name, but the way they're portrayed is so obvious that you're talking about X. And you're portraying them in a defamatory way, i.e. you're maligning them, then you could be open to challenge. But at that end of the spectrum, you've got quite a free rein, and just be careful about things such as defamation. But that will only apply if it got to the point where people thought, well, hang on, you're really talking about X. But going to the other end of the spectrum, where you're trying to do something as close to fact as possible, then you've got to think. I think the first point you of call is, what are you using as your source materials to write the story? If you're basing it on public documents, information in the public domain, then that's fine, because that's already accessible. If you're the only thing I would say, if you are doing that, you keep, and I've advised this, people I've seen at Screenwriters, I've advised, keep a clear log and a record of where you got your sources of information. Because if you can say, look, I got that from the public library, or I went down to the electoral register and I found out about this or that, or something, then you're on safe ground. If you are trying to base your script around a book that's being written, at the moment they're publicising Charles Moore's book on Margaret Thatcher as an example, and you're using stuff that's really can only be sourced from that book, then you have got to go to Charles Moore, his publishers, and say, I need to option the book because I want to use what's out there. But if you can source the same information from from public domain, then that's another story. And
what is public domain as opposed to a book that's been written by an author? Would the newspapers or the news be public domain?
Yes, I mean, if it's a big, well-known event, say like Hillsborough, or something that is being saturated with news, where you're piecing the story together from different sources, that would be public domain. If, however, it's something a bit more bespoke, where really you're relying on a particular article and you're trying to glean from only that one sole article or book or whatever, then you really would need to do one or two things: either go and option the article, or alternatively go off and do your own research. So you say, look, I may have been inspired by that article, but this story is based as a consequence of my own independent research. And then the other aspect is, if you are using real names and you're going to use real people and depict them in the script, you've got to think how you portray them. First of all, you've got to be careful of the laws of defamation, and not sort of make up things that are not true. I mean, our caveats that you inspired by a true story, is based upon a true story, if you look at the film credits at the beginning or the end, there's certain things in there that give some protection. Sometimes you may want to actually work with the personality, and so you approach them and say, well, will you work with me? You might get a far greater insight than you, but obviously you got to option. They may want money to do that, but not probably. But so it doesn't prevent you, but you just got to be very careful about how you write about real living life people. And the other thing is, if you're particularly, we all want to get our scripts and films into the international domain, and the rules on what's called image rights or laws of privacy vary from country to country. Over here, we don't have a concept of image rights, but if I go into the USA and want to have a film about Mick Jagger, I do a film on Mick Jagger here and portray him, provided I meet all those criteria, don't defame him. I'm using independent research, etc., etc. And if some of the scenes are fictionalised, it's quite clear. You caveat it, so it's based upon real life, but some part of it is fictional. But if you go into somewhere like the US and you're using Mick Jagger and you've got an actor depicting him and somebody looks like him, sounds like him, whatever, you could be he could injunct you and say, you're abusing my image right. You're using my name, you're using my look, my demeanour. So you would need to probably then work with him, his record company or agent.
So I guess the deal is, if it's in very recent memory, you want to try and get people who are directly involved, if you can, get them signed off, get them to sign contracts, but that's in itself potentially costly and time consuming.
Yes.
But as it slips further and further back into time, I guess if it becomes a historic event, it becomes less problematic.
It's less problematic. If you're writing about dead people, you can't defame the dead.
Yeah.
And unless, the same rules apply if your source materials are from autobiographies, biographies, and it's quite clear you're sourcing from them, and you've got to option those books. But if you're getting it from more common public domain material, then that's a different story. But the further back in time, it's an easier process for the reasons I outlined.
Okay. So the next question I've got is, what are the legal pitfalls or implications or complications of having a co-writer?
I think yes. This probably the advice I give here could apply to any situation, whether you're setting out a solicitor's practice, a building contractor's practice, whatever. It's the first thing is always work with people you can trust and get on with. You have all the contracts in the world. If you don't have those basic premise, that's and also you've got to feel comfortable. And if you meet those criteria, and we know, there's lots of writing relationships out there over the years that, where there's no contract, they rub along well, they work well together, and it works. These days, quite often you do need written agreements purely because, you've mentioned, the chain of title and investors and whatever, and the insurers want to see the DNA of legal rights and so forth. I talk from personal experience. So I've optioned a book with somebody, and we're going to co-write and hopefully turn it into a drama series, TV drama series. And we've got a little agreement, nothing too fancy, just a little 2-pager, just to sort of set out some parameters. That we both, in terms of equal credit, equal share of monies. Then we've also put in a few caveats that if one of us has to drop out and the other person takes over the writing, then it's reflected that they will get a much larger share of any revenues. The other person will still get some revenue and a credit. So these things are a question of sitting down and thinking through. You can't allow for every contingency. I think one of the, in any creative process, and maybe it's the best, you need it, is what happens if there's a stalemate on how you write the script, and one person says, no, I think that scene should be like that, and you think the scene should be like that. It's because of the unique set of facts. This person brought the book to me. They got a far better knowledge of the book than me, and I've agreed. They've brought me on board, which I really appreciate. And I've said, if in moments of disagreement, their view will carry weight, but that's unique circumstances there. So things like that need to be thought about. I mean, it could be you just do the two versions of the script, and you just submit two versions of the script and see what the producer's like. I mean, that's one.
A little problematic, but it's one way around. But I guess the bottom line is, I think many people think that contracts have to be, done by big lawyers and be, really absolutely watertight, if that's even such a principle. But actually, for something like I'm going to write with my friend a script, you can sit down and just write a 28-point, almost like a bullet list, and say, we agree to all of these points, and you both sign it and date it and witness it even, if you want. Yeah. And that's kind of binding.
That's right. I mean, you can have a contract with somebody without it actually being written. The downside of that is that he's trying to prove the terms. Yeah. I remember many years ago spending 9 days in the High Court trying to prove we proved the contracts, but we couldn't prove all the terms. And so you don't want to go down there. And the great thing about writing things down is people's memories do dim. I thought it was this, no, I thought it was that. So, and we're all guilty of that. So, no, I think use good, clear English. I mean, one of the things about, I see handwritten, homegrown agreements, and my biggest criticism is that it's the way it's worded. It creates ambiguity. Use things like, we will equally share the monies, we will have equal credits, keep it simple, keep it clear. And if you both think it should be looked at by a lawyer just to give it a once over, might do a little tweaking, twiddling, but if you've done the core work well, there's no reason why you can't have an agreement.
And of course that process forces everyone to confront all of those things that they may not have thought about. Like, actually, do we have alphabetical double billing? Who goes first? Does somebody get a bigger name or not? Because they may have brought more to it.
Yeah.
So it forces you to confront all of that stuff before you spend a year for getting in bed with that person and then discover you have a really big problem at the other end.
It's a good testing ground. I mean, just confronting these things, because the number of times when people, you mustn't, you've got to be give and take, and if you feel that you can't even agree some basic terms, then don't write with that person, because what happens when you get to scene 4 and there's a big argument, does she die, doesn't she die, or whatever.
Complications. Okay, that's pretty much all the questions I've got. I have one last personal question, which I ask everybody. What are the biggest mistakes that you see over and over from emerging screenwriters?
Over enthusiasm. That enthusiasm should be bottled, nurtured, preserved, respected. But if it overshadows everything else, at the end of the day, we all want to be creative, we want to do great things, but we also have to remember it's also, it's meant to be a living, it's a business, so you've got to try and temper it. Whether you temper it because you're commercially savvy by nature, or you think you could get a mate on board who can help you, or you get you pay for professional advice to be the person that sort of says the cool thinking one, but that I would say over enthusiasm, realistic expectations, and also take the knockbacks. And also if you do get knocked back, keep trying again.
Fantastic, Julian. We'll see you at the festival.
Look forward to it.
Thank you very much.
Pleasure, absolute pleasure. Good luck, Chris. Take care.
Thanks.